So the battle over the Texas border and the Biden administration's immigration policy just got even more interesting after a new order from the Supreme Court. So let's talk about what just happened. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. A lot of you guys know that I've been supporting 1st Phorm for a long time. They've supported this channel. They're pro-freedom, pro-2A. They have amazing supplements if you're interested and you're just trying to get healthier. If you're interested, check out 1st Phorm. I will leave links to them down below. And also, if you use that unique link, if you order something over $50, you will get a free 4-pack of energy drinks. As I mentioned in the intro, in this video, we need to talk about a new decision that was just issued by the Supreme Court. And this order by the Supreme Court was in direct response to the Biden administration and their new policies, a new program that they put in place in regards to the border and immigration. And this was an unconstitutional rule. Here, the Biden administration engaged in agency overreach, and now this has been struck down. Recently, 16 states joined together to sue the Biden administration and the Department of Homeland Security over their unconstitutional rule, which aimed to essentially grant millions of illegal aliens, parole in place status, and subsequently grant them citizenship. This issue was pending in front of the Supreme Court, and the Biden administration was seeking emergency intervention from the Supreme Court. They want the Supreme Court to step in and grant a writ of cert before judgment to bypass all the lower court review, or to issue a writ of mandamus against the Fifth Circuit in what they had said in this case. But we just received an order from the Supreme Court which denied that request. This order comes off the heels of what the district court there just said. They just issued a ruling on the merits, and it went against the Biden administration. This decision falls in line with the growing list of new cases and new decisions which are striking down rogue agencies and the overreach and rulemaking that they are engaging in. The Biden administration, through the Department of Homeland Security, created a new program that effectively provided a pathway to green cards and then eventually citizenship for millions of individuals who came into the US illegally. Again, this was all done through a new program, and it was a unilateral agency action on part of the Biden administration and also the Department of Homeland Security. As a result of this agency overreach, 16 states led by the state of Texas joined together to file a lawsuit against the Biden administration and this program. Well, we recently received a decision from the court there agreeing with the states, and therefore they struck down this Biden administration rule and this new program. And after that decision, the Supreme Court just issued a new order also denying the review that the Biden administration wanted. The Biden administration wanted emergency intervention, but that was also denied. In this case, the states argued that this is a challenge to unlawful agency action taken by the Department of Homeland Security to create a program that will grant hundreds of thousands of illegal aliens parole in place status, PIP status. Longstanding federal law prohibits aliens who enter the United States unlawfully from obtaining most immigration benefits. This includes obtaining lawful permanent resident status without first leaving the United States and waiting outside of the United States for the requisite time. These provisions of law established by Congress serve as powerful disincentives for individuals to cross the border unlawfully. Indeed, were they not present, there would be no practical reason for any alien to abide by the law, wait his or her turn, and only come to the United States when the law provides. But the Biden-Harris administration, dissatisfied with the system Congress created and for blatant political purposes, has yet again attempted to create its own immigration system in two new ways. They go on to state that, claiming that it has unfettered discretion, implementation of the Keeping Families Together Act, Department of Homeland Security has announced the creation of a program that effectively provides a new pathway to a green card and eventually citizenship, announcing that it would allow more than 1.3 million individuals who are unlawfully present in the United States, citizen status, and that would include more than 200,000 individuals that have come into the state of Texas. They go on to state that specifically the Department of Homeland Security has announced a new PIP program that would allow aliens who have been unlawfully present in the United States for 10 or more years to receive a grant of parole without leaving the United States and attempting to come back and apply for admission at a lawful point of entry if the alien is the spouse or stepchild of a U.S. citizen. Now, one of the main challenges that is brought by these states against this program is essentially they don't have the authority under the text of the statute. The statute is very specific on the language that it uses. The statutory language being used here does not allow for paroling mass amounts of individuals, and it also does not apply to individuals who are already within the United States. the Biden administration twisted the statutory language to create a new program that clearly was in conflict to what the text actually says. The states argued that this new program was actively incentivizing more people to illegally enter the United States, and they were also coming into various states as well because of this policy. Originally in this case, Judge Barker issued a preliminary injunction against this program. Now, in response to that preliminary injunction, the Department of Homeland Security and the other defendants here tried to appeal that up to the Fifth Circuit, but on review, the Fifth Circuit ruled against it. There was also an attempt by the Coalition for Humane Immigration Rights and 11 other individuals to intervene in this case to join the Department of Homeland Security as defendants. However, the district court there denied that request. Now, as a result of that, those intervener parties also then appealed to the Fifth Circuit, but they were denied once again the request to remove the administrative stay, which was ultimately blocking the enforcement of this program. Now, after losing in the Fifth Circuit, those defendants, the intervener plaintiffs, then went to the Supreme Court seeking Supreme Court emergency intervention in this case. The defendants here wanted for the Supreme Court to let them participate in the case, but also some of the defendants wanted the Supreme Court to step in early to issue a writ of cert before judgment or a writ of mandamus against the Fifth Circuit to essentially override what the Fifth Circuit had said. Now, while all of that was still happening, the district court was hearing arguments on the merits of this case. Well, this all came to a head recently, and the district court issued a final decision finding that the Biden administration and this DHS program is in fact invalid, and therefore he struck it down. Now, in this decision, the judge stated that the court declares that defendants lack statutory authority under the statute itself to grant parole in place to aliens, as that term is used in the final agency action, or to deem parole in place as used there to be the parole into the United States for the purposes of the statute. That agency action is hereby set aside and vacated. So that was a huge decision that was issued at the end of last week. However, there was still an emergency petition pending in front of the Supreme Court, like I mentioned. The intervener parties and the defendants there were asking for the Supreme Court to step in early, grant that writ of cert before judgment, and also a writ of mandamus against the Fifth Circuit. Well, we just received an order from the Supreme Court in response to what happened in the lower court, what the district court said in their final judgment, and the Supreme Court has denied the request for the emergency intervention. Justice Alito, who was in charge of that emergency application to review it and consider it, he has issued an order denying that request. In his order, he says that this request is now moot because of the lower court decision, and they have denied the review. So the Supreme Court, through that order, has dug another dagger into this case, and the Biden administration is now running out of options, and they are also running out of time because of President Trump being elected. And if they're going to try to litigate this case, they got to really get it done within the next couple months. And also, if anything that they do, if it's not resolute, if it's not final, essentially the Trump administration could just scrap it, do away with this program, do away with the policy, and then also do away with the litigation if it's not finalized. Currently, the Biden administration can appeal the district court's decision up to the Fifth Circuit, but I don't think that will go very well for them because the Fifth Circuit has been against them and just general agency overreach all along. They could also seek an application from another justice on the Supreme Court. Now that Alito has denied it, they can kind of shop for another justice like Sotomayor or Kagan or Ketanji Brown Jackson. But ultimately, to reverse the application or to take review of this case, you would have to have enough Supreme Court justices who want to take on this issue, and I just don't think that they have the numbers. Now, this case is important not just because of the border considerations, but also because this case is using various Supreme Court decisions like the Cargill case and other agency overreach cases that we have followed on this channel, and they're using those precedents in the Fifth Circuit and the Supreme Court to strike down even more agency overreach. And this is a good sign going into the Trump administration, because if we are already still getting wins, even under the Biden policies, it's going to look very good for us going into the Trump administration. So hopefully you guys found this video helpful. We will now see how the Biden administration responds after this decision, and then also the subsequent Supreme Court denial. If you guys have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.